Breaking news, an appeals court judge rejecting Trump's bid to pause the Trump Organization fraud trial. But the judge did agree to temporarily halt the process of breaking up Trump's businesses. This is a former top Trump Organization deputy testified to fraud on the witness stand today. Jeff McConey is his name. He's the former controller and a co-defendant, testifying that he significantly inflated the valuation of Trump properties and that he did so, and what we heard today, at the direction of Eric Trump, Trump's son. According to McConey, he was told by Eric to include the value of 7 homes when valuing a development called Seven Springs, even though those homes were not even built. McConey also testifying that he continued to value Trump's Briercliffe Manor Golf Club at $101 million for 4 years. The appraisal was less than half of that value. So why did he do it?
Breaking news. 4 words, that is all it took. Leave value as is. Those 4 words delivered by Eric Trump to the man responsible for running the numbers at the Trump Organization are now on the record in a Manhattan courtroom, spoken under oath by a co-defendant about a golf club that an independent appraisal showed was worth less than half of what Trump's financial statements claimed. Jeff McConey is the former controller of the Trump Organization. He is also a co-defendant in the New York civil fraud trial. And today, on the witness stand, he testified that he significantly inflated the valuations of Trump properties and that he did so because Eric Trump told him to. 2 specific examples dominate today's testimony. First, Seven Springs, Trump's 212-acre estate in Westchester County. McConey was told by Eric Trump to include the value of 7 homes that had never been built, phantom homes, hypothetical construction valued as if it already existed. The estate Trump bought for $7.5 million got valued on financial statements at numbers that reflected a residential subdivision that existed only on paper. Second, Briercliffe Manor Golf Club. McConey valued it at $101 million for 4 consecutive years. An independent appraisal showed it was worth less than half that. When McConey asked what to do, Eric Trump said, leave value as is. An appeals court today rejected Trump's bid to pause the trial. The testimony is in the record. The fraud, according to the man who actually ran the numbers, came from the top, and it ran directly to Eric Trump. Before examining what McConey said, it is essential to understand who he is, because the nature of his testimony is legally and humanly remarkable in ways that deserve to be understood fully. Jeff McConey is the former controller of the Trump Organization. He spent years at the organization responsible for the financial statements at the center of this case, the documents that overstated property values to banks, insurance companies, and other financial counterparties. He is not a peripheral figure. He is the man who ran the numbers. He is also a co-defendant. The New York Attorney General is seeking financial penalties from McConey personally, alongside Donald Trump, Eric Trump, Don Jr., and the Trump Organization itself. He is being sued for the same fraud he is now describing from the witness stand. That combination, co-defendant testifying about his own participation in fraud and naming the people who directed him, is not standard courtroom behavior. In most civil cases, co-defendants have aligned interests. They present a unified defense. They minimize and dispute together. McConey is doing something fundamentally different. He is on the witness stand describing what he did, how he did it, and who told him to do it. Naming Eric Trump by name, describing specific conversations, recounting specific instructions. The legal incentive structure behind this choice is important to understand. McConey's best path to minimizing his own personal liability is to establish that he was acting on instructions from above rather than exercising independent, fraudulent judgment. If the direction came from Eric Trump, if McConey was told to include phantom homes and told to leave inflated values unchanged, then his personal culpability is reduced relative to the people giving those instructions. The man who ran the numbers on orders is in a different legal position than the man who gave the orders. Whatever his motivation, the result is testimony that no document could provide on its own. Documents establish that the fraud happened. McConey's testimony establishes how it happened and who directed it. The Seven Springs detail is the clearest single example of how the fraud actually worked, and it deserves to be understood in full because it illustrates something specific about the nature of the misrepresentation. Seven Springs is a 212-acre estate in Bedford, New York that Trump acquired in 1995 for approximately $7.5 million. The original plan was to develop it as a luxury residential subdivision, build homes, sell them, generate profit. That development never happened. Local opposition, environmental review complications, regulatory complexity, the homes were never built. Not one. The land remained undeveloped. When McConey was valuing Seven Springs for Trump's financial statements, Eric Trump told him to include the value of 7 homes that had not been built. Homes that existed only as a concept, a plan, a hypothetical on an architectural drawing somewhere. McConey was instructed to value those phantom structures as if they were complete, finished, habitable homes, and to factor that fictional square footage and fictional completed development into the financial statements. The estate Trump bought for $7.5 million and that had no completed residential development on it was valued on his financial statements at numbers that reflected a suburban subdivision that existed only on paper. This is the precise definition of fraud in this context, not aggressive valuation of future potential, not a legitimate difference of opinion about how to account for development rights, stating as present value something that did not exist, including in a financial statement assets that had never been built and might never be built. And doing so because Eric Trump gave the explicit instruction to include those phantom homes in the calculation. Attorney General James had already registered the judgment against Seven Springs in Westchester County in anticipation of enforcement, noting that Trump had claimed the property was worth hundreds of millions based on development rights that were never approved, never built, and never likely to be approved given local opposition. McConey's testimony provides the specific human account of how those inflated numbers were generated, a phone call or conversation with Eric Trump, and an instruction to include value that was not real. If Seven Springs illustrates the fraud through the active addition of fictional value, Briercliffe Manor Golf Club illustrates it through the deliberate maintenance of known false value. And the 4 words that capture that maintenance, leave value as is, are now among the most legally significant phrases in the entire civil fraud case. McConey had an independent appraisal of Briercliffe Manor, a professional evaluation by a qualified appraiser using standard methodology showing the club was worth less than $50 million. He had this appraisal in hand, he knew what it said, and he continued to value Briercliffe Manor at $101 million on Trump's financial statements for 4 consecutive years. When he sought direction on what to do, when he raised the question of whether the valuation should be updated to reflect what the independent appraisal showed, Eric Trump gave him his answer: leave value as is. 4 words, no ambiguity, no alternative interpretation available. The appraisal said one number. The financial statement said another number that was more than twice as large. Eric Trump said, keep the larger number. Do not update to match what the qualified appraiser found. Leave value as is. The phrase is legally devastating for a specific reason. It establishes knowledge. When Eric Trump told McConey to leave the $101 million valuation unchanged despite an independent appraisal showing it was less than half that, he was not confused about what the appraisal showed. He was not operating under a different valuation methodology. He knew there was a professional appraisal. He knew it showed a lower number. He chose to maintain the inflated figure anyway. That is not negligence. That is not aggressive but defensible accounting. That is a deliberate instruction to maintain a false number on financial statements that were going to banks and insurance companies. The knowledge is explicit. The direction is explicit. And the man who received that direction is now on the witness stand describing it under oath. The legal significance of McConey's testimony shifts the analysis of Eric Trump's position in this case in a specific and important way, from beneficiary of fraud to director of fraud. Being a beneficiary of fraud means you profited from false financial statements that others produced. Being a director of fraud means you specifically instructed the people producing those statements to use false numbers. Those are different legal positions, and the difference matters enormously for questions of personal liability and culpability. Before McConey's testimony, the evidentiary case against Eric Trump rested primarily on documents, his signatures on financial statements, his presence in meetings where valuations were discussed, his role in the organization that produced the fraudulent numbers. Documents establish that he was there and that he benefited. They are less effective at establishing that he personally directed the specific decisions that produced the fraud. McConey's testimony provides exactly that. He is not testifying about documents or signatures or organizational charts. He is testifying about specific conversations in which Eric Trump gave him specific instructions, include the value of 7 homes that had not been built, and leave the inflated golf course valuation unchanged despite an independent appraisal to the contrary. That places Eric Trump in the room directing the fraud, not just signing off on numbers someone else produced, not just benefiting from an organization that inflated asset values, but personally instructing the controller responsible for those numbers to use values he knew were false. Michael Cohen, Trump's former personal attorney and fixer who spent 11 years working inside the Trump organization alongside McConey and Alan Weiselberg and Eric Trump, assessed McConey's testimony with the directness of someone who knows these people personally. The fraud, Cohen said, does not start and stop with Donald Trump. It goes to the children. Eric is in serious trouble. Cohen's credibility as an analyst is complicated by his own history. 8 felony guilty pleas, 3 years of incarceration, subsequent cooperation with prosecutors, and Trump's lawsuit against him. But in this specific context, his value is not as an objective observer. It is as someone who was inside the organization, who knows how decisions about financial statements were made, who worked alongside the people now testifying. When he says Eric is in trouble based on what McConey described, he is pattern matching against direct knowledge of how the organization actually operated. Today's appeals court ruling contains both a significant development in Trump's favor and a significant development against him, and understanding both is necessary to accurately assess where this case stands. The bad news for Trump, the appeals court rejected his bid to pause the trial entirely. Trump's legal team had argued that the trial should be suspended while the appeal of Judge Engoron's September summary judgment was pending. The appeals court said no. The trial continues. McConey's testimony was given in open court, on the record, fully reportable, while the appeal was pending and while Trump's team had no judicial mechanism to stop it. That means every day of trial testimony, every specific detail about phantom homes and leave value as is entering the permanent legal record regardless of what ultimately happens on appeal. The testimony cannot be ungiven. Engoron has heard it. It will inform his final judgment. It will be part of the appellate record. It will be cited in legal analysis and journalism for years. The partial good news for Trump, the appeals court did temporarily halt the process of breaking up Trump's businesses. Judge Engoron's September summary judgment had ordered the cancellation of Trump Organization business certificates, the legal entities that allow the businesses to operate in New York, and required the preparation of a receivership plan. That specific piece is now on hold while the appeal proceeds. The distinction matters in practical terms. The immediate, operationally devastating consequence of actually dissolving Trump's business entities, the scenario in which a receiver takes control of Trump Tower, Mar-a-Lago, and the golf clubs and begins a structured liquidation, is temporarily paused. The businesses can continue operating for now, but the testimony is not paused, the trial is not paused, and the permanent record being built by McConey and other witnesses will be there when Engoron issues his final judgment, a judgment expected to exceed $450 million in disgorgement penalties. Judge Engoron's September summary judgment found fraud on the basis of documents, financial statements that overstated property values, appraisals that were ignored, numbers that bore no relationship to independent market assessments. The documents established that the fraud happened. What McConey's testimony provides is something that documents alone cannot: the human account of how it happened, who decided to use these numbers, who knew they were wrong, who gave the instructions that produced the false valuations. The answer, according to the man who ran the numbers and is now testifying under oath about it, involves specific conversations with Eric Trump, specific instructions to include homes that did not exist, specific instructions to maintain a valuation that an independent appraisal had already shown to be false. That specificity, the phantom homes at Seven Springs, the leave value as is at Briercliffe Manor, the direct line of instruction from Eric Trump to the controller responsible for the financial statements, transforms the fraud from an abstraction found in documents to a concrete account of deliberate decision-making by specific people who knew they were working with numbers that did not reflect reality. Engoron, who will issue the final judgment in this case, is the sole finder of fact. He evaluates witness credibility, weighs documentary evidence, and makes all factual determinations. He has already found before the trial began that the fraud occurred. He is now hearing testimony about the mechanism and the perpetrators from the man who actually ran the numbers. When he issues his judgment, expected in early 2024, it will cite the phantom homes and the leave value as his instruction as specific examples of the deliberate inflation of asset values. Those details, delivered by a co-defendant under oath in a Manhattan courtroom on an October afternoon, will be in the legal record permanently, cited in appellate filings, analyzed in legal scholarship, part of the documented history of one of the most consequential civil fraud cases in New York State history. 4 words spoken in a conversation years ago at the Trump Organization, told to a controller about a golf course valuation that an independent appraiser had already corrected. Leave value as is. Those 4 words are now in the record, and they will remain there. Here is today's question, and it goes to the heart of how corporate fraud actually works. A Trump Organization co-defendant just testified under oath that he inflated property values because Eric Trump specifically told him to, including valuing 7 homes that were never built and maintaining a golf club valuation at more than twice what an independent appraisal showed. Does testimony like this change your understanding of who bears responsibility for the fraud? And what do you think happens to Eric Trump legally from here? Drop your answer in the comments. This community brings some of the most informed legal and political analysis anywhere on this platform. The best responses get featured in our next video. Sal to action. If this breakdown gave you the full picture of what happened in that Manhattan courtroom today, hit that like button right now, 2 seconds. That is all it takes. Subscribe if you are not already here. We cover the legal stories that matter with the depth and precision they deserve. Turn on notifications. This trial is moving fast, and the next major development could come at any moment. Share this video. Send it to someone following this case who deserves the full picture of what McConey's testimony actually means. This is the breakdown they need. Stay sharp, stay informed.